introductions. My name is Samantha Ord, and I'm the Vice President of the Federalist Society here at OCU Law. And we are here today to discuss a topic called Click to Shoot, the First Amendment, Second Amendment, and 3D printed guns. So we're joined today by Professor Josh Blackman of South Texas College of Law, Professor Rick Tepker of OU, and Professor Michael O'Shea of OCU Law to discuss 3D printed guns, concealed carry, and other recent Second Amendment developments. So here is a statement of purpose of the Federalist Society. So what is FedSoc? The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what the law should be. The Society seeks to both promote an awareness of these principles and to further their application through its activities. If you would like any more information about joining the Federalist Society,
you should join.
And you should join. It's at www.fedsoc.org/join. And if you have any questions about that, you can come talk to me or Ben Frizzell, who is our president. Hopefully he'll be here soon. And here is the little disclaimer that we like to say at the beginning of each of our events. Please note that our goal is to encourage the exchange of ideas on campus. As such, we do not promote particular policies, endorse nominees or candidates, adopt political stances, or advocate for political outcomes. Any speaker's views are their own and do not represent an official position held by the Federalist Society. So the format of our panel today is going to be, I'm going to introduce each of the speakers, and then each speaker is going to have 10 minutes, and then there's going to be 3 minutes for comments after each of the speakers gives their introductions and their comments, and then 10 to 15 minutes for Q&A, and that'll be at the end of it. And I'll have a microphone that I'll be passing around for people to ask questions. So audience participation is encouraged for questions and answers. So I'm going to introduce each of our speakers today. First is Josh Blackman. He is an associate professor of law at the South Tulsa.
My goodness.
I'm from
South Tulsa. We are south of Tulsa, that's true.
Yes, they are south of Tulsa, but this is the South Texas College of Law in Houston, who specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. Josh is the author of the critically acclaimed Unprecedented, The Constitutional Challenge to Obamacare, and Unraveled, Obamacare, Religious Liberty, and Executive Power. Josh was selected by Forbes magazine for the 30 Under 30 in Law and Policy. Josh has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. He is an adjunct scholar at the Cato Institute and is the founder and president of the Harlan Institute, the founder of Fantasy SCOTUS, the internet's premier Supreme Court fantasy league.
You should all play.
And blogs at joshblackman.com. Josh is the author of over 4 dozen law review articles, and his commentary has appeared in the New York Times, the Wall Street Journal, Washington Post, USA Today, the LA Times, and other national publications. Next, we have Professor Michael O'Shea. He is a nationally recognized expert on firearms law and the Second Amendment, whose scholarship on the right to keep and bear arms has been regularly cited by federal and state courts. His current scholarly interests include the selection of state court judges, the role of tradition in constitutional interpretation, and critical perspectives on contemporary originalism. He serves as the Associate Director of OCU Law's Center for State and Constitutional Law and Government. Professor O'Shea is an honors graduate of Harvard College and Harvard Law School. Before coming to Oklahoma City University School of Law in 2006, he practiced commercial litigation in Chicago and in his hometown of Kansas City, Missouri. He also served as a law clerk to Chief Judge Danny J. Boggs of the U.S. Court of Appeals for the Sixth Circuit. And lastly, we have Professor Tepker. He is a 1973 graduate of Claremont Men's College. He earned his law degree in 1976 from Duke University, and prior to joining the OU faculty, he practiced law for 5 years in Los Angeles, specializing in labor and employment issues. Rick Tepker is the first member of the OU law faculty to appear, argue, and win a case before the United States Supreme Court. In 1987, the court appointed Tepker as counsel for a petitioner, an indigent juvenile sentenced to death. It was the first case in which an American court overturned a death sentence on constitutional grounds because the condemned was too young at the time of the crime. Tepker also participated in U.S. Supreme Court cases involving Title VII and academic freedom, seniority systems, and timing requirements for filing, as well as a seminal age discrimination case that led to congressional action regarding early retirement practices. So let's give it up for our panel.
Thank you. Thank you. I don't need this for the recording. Thank you so much. My first time at OCU, my first time in Oklahoma. It's a pleasure to be here. Our topic today broadly is about the Second Amendment, and my colleagues will talk about actual guns. I want to talk about something a little bit different. Using technology to make guns, specifically 3D printers. So how many have ever used a 3D printer? Every time I give a talk, more hands go up. Okay, what is a 3D printer? It's a way of designing an object on a computer. And you have this device, and it spits out little bits of plastic, one on top of the other, and it makes objects. Now, the event's called click to shoot. Not entirely accurate, but the general idea is if you download files to make a 3D printed gun, and you do stuff to those files, and you choose certain materials, you can actually create a functional firearm. Now, there's nothing novel about making a gun at home. A lot of people think there is. I can take you to the hardware store, buy you $10 worth of parts, and make a fully functional rifle that's not detected, may have rubber. A piece of rubber tubing, all you need for a rifle. So there's nothing novel about making undetectable firearms with guns. My interest, in which I've been litigating now for several years, is can the government restrict the information needed to make these guns? In other words, can you put the files on the internet that one can download to use to print guns? And I've been litigating this issue since 2014, feels like forever. Long story short, at first the Obama administration said, you can't put these files on the internet. Doing so violates arms control laws, right? Putting a file on the internet is a form of exporting of arms, and we've litigated that for a couple of years. And then states started getting involved. New Jersey passed a statute that made it a crime to put a file on the internet, right? And I want to just take a step back. Generally, states aren't involved in regulating the internet for good reason. This is something that involves interstate commerce. I think we all agree, even those Federalists among us. And this should be a matter for federal regulation. But states are now trying to say that you can't put these files on the internet because by putting a file on the internet, someone in my state can download it and print a gun. Okay. We've argued that these laws actually violate the First Amendment. And let's make a couple of basic points. The mere fact that you convey speech through electronic format in code doesn't deprive it of First Amendment protection. We've had Supreme Court cases involving violent video games. We've had cases involving algorithms. We've had cases involving credit reports. Just because it's not speech, the way you and I are talking right now, doesn't mean it's unprotected. But then you would say, wait a minute, Josh. Guns are different, right? If you can use speech to commit a crime, that's not protected. That's not exactly right. The Supreme Court has said that you can only ban you can only ban speech if there's some sort of imminent threat, that will lead to the commission of a crime. And this sort of code does not have that imminent threat. It requires a lot of work, a lot of downstream usage at the end before you can take a file and make it into a functional firearm. Additionally, there's a lot of usage of these these files, not for guns. They've been displayed in museums. They've been studied in universities. They're artistic. They've been displayed in art galleries, right? The overwhelming majority of people who download these files will never actually print the gun. So we have overbreadth problems, right? Where they're sweeping in a lot of protected speech to go after perhaps a small sliver of potential criminal activity. So we've argued pretty strenuously in court that the files at issue here are protected speech. We've argued that they are governed by the First Amendment, and that states who try to restrict this speech impose what's called a content-based restriction. That is, they're restricting speech based on what it looks like on the screen, or based on what it can generate downstream with the printer. And generally, the Supreme Court has held that a content-based restriction is governed by strict scrutiny, right? And as we know, it's generally pretty hard for a law to survive strict scrutiny unless it involves guns, in which case the courts rule against the Second Amendment on a fairly consistent basis. Now you would say, wait a minute, Josh, the printing of the gun isn't speech, right? That's more like conduct, maybe like it's like flag burning or burning a draft card. We actually haven't litigated the question whether you can print the gun, right? Our entire litigation is a threshold issue. Can you stop people from sharing information about the gun? There are different inquiries, right? Over the summer, I actually had to argue for temporary restraining order cases in 5 days in different courts. It was pretty much of a blitz. And perhaps the most surreal experience was on the eve of my oral argument. We were sued by 20 states seeking a nationwide injunction. President Trump subtweeted me. It's true. President Trump tweeted, "Who are these people trying to sell plastic guns? I need to talk to the NRA." Well, the NRA was not helping us, and the judge actually cited the tweet during my oral argument. It's very difficult, where the judge says, "Why don't you do what the president says? Stop with these stupid plastic guns." But we have not actually discussed selling the plastic guns. We don't make the plastic guns. The extent of our activity is putting these files on the internet. So for a couple of reasons, the states can't punish these files. I'll walk you through our arguments. First, we have a content-based restriction, right? The mere fact these guns can be used to facilitate a crime doesn't give the state the power to shut down this speech. This is censorship. Secondly, what's called preemption. Some years ago, Congress enacted a law called the Communications Decency Act, CDA. You probably know this in context of intellectual property, right? If you have a video on YouTube that's pirated, right, stolen, YouTube takes down the clip, right? We all know this happens. This law says that the regulation of the internet for these sort of takedowns are matters of federal law, not state law. States can impose restrictions on what goes to the internet. That's all preemptive. We also have due process issues, right? Try thinking of how to craft a statute to make it a crime to share information. It's actually very hard. New Jersey drafted a statute that's so broad. It says if you put on a file that may be used to make a gun, we read that statute really broadly. That would apply to using a nut or a screw or a bolt. Why? You can use a screw to make a gun. So any part that can be used to make a gun can now be banned from being put on the internet. Way too broad. That's what's called void for vagueness, and these statutes have a lot of problems. I argued in district court a few weeks ago that this statute New Jersey has is as narrowly tailored as a burlap bag, right? It does not have any specific carve-outs. We also have the Second Amendment, and this is, I'll seg my way into Professor O'Shea's presentation. We've argued that the Second Amendment includes a right to actually make guns. We don't say that this we don't say that this activity can't be regulated, right? We think that perhaps regulations about having a serial number, or if you want to have to add a quantity of metal. But the basic elements of the Second Amendment involve the right to make a gun. You say, wait a minute, Josh, I read Heller. I read Justice Scalia's opinion. I don't remember him saying anything about making guns. Let me tell you something. Before Walmart, right, before Dick's Sporting Goods, right, before Cabela's, if you wanted a gun, you had to make it yourself, right? The Minutemen, the militia, they weren't going down to your local gun store. They were manufacturing their own firearms, right? They made their own musket balls. They made their own arms, their own ammunition and the like, their own gunpowder. They made their own weapons. And it's a very long-standing, deeply rooted tradition in this country of making your own guns. Believe it or not, under federal law, you can make your own gun. As long as it's not an automatic weapon, short-barreled shotguns are out, and you have to have some metal in there, you can make a gun, and guess what? You don't need to tell the state about it. You are on your own. So we argue. You can't sell it, though. You can't sell it. Oh, that's my next point. You cannot put it into the stream of commerce, because then you're in big, big trouble. But if it's for your own usage. So to the extent that we look to tradition, right, there's a very long-standing basis for making your own weapons, and 3D printing is just another way of doing it. This really just scares people. This is a non-issue. These guns are crap. They're terrible, right? They're not accurate. They fire one gun bolt at a time. They're likely to overheat and blow up in your hand. They're not very good guns. I think they scare people. Think, oh my God, we can have people sneaking guns into courthouses and airports. Let me tell you something. Plastic guns aren't new, right? In 1987, was 87 Undetectable Firearms Act? Yeah, 87. Congress enacted the Undetectable Firearms Act, which banned plastic guns. 30 years ago, right? You weren't even born yet when this statute was passed. So the threat of undetectable plastic guns is not new. And 3D printing, frankly, is not very easy. It's expensive, it's time-consuming. It's hard to make a gun that's functional. This is a ghost problem. It's not an actual problem. There's no evidence he's ever been used in a crime. And I'll tell you something, it's a lot cheaper to just buy a gun on the black market than to print your own. So I don't see this as an actual public safety issue. I think it just makes people upset and paranoid, as most gun issues often do. But I do think it's important to stress that we are litigating primarily as a First Amendment case. You have the right to share this information. I'll stop here. Okay, thank you. Professor O'Shea, and I'll be welcome for your questions later. Thank you all so much.
So I'm going to focus exclusively on the Second Amendment. And as Josh mentioned, the overlap between my remarks and his is I do think that there is at least conduct within the scope of the Second Amendment's protection going on in the defense distributed case, in the 3D printed guns case. And it's because the right to keep and bear arms has historically been understood to protect kind of corollary activities that allow people to maintain the what Dave Kopel sometimes calls the material culture of the right to arms. And that includes activities like customizing your own guns, transporting them to be worked on or repaired, and to make homemade firearms. And so I agree, there's constitutionally protected activity there. And the Second Amendment question raised by Josh's case is how far can that go? What aspects of it, if any, can be prohibited? And then what sorts of regulations are permissible? I agree that, you know, a serial number requirement strikes me as an example of a regulation of homemade guns that would be pretty uncontroversial. I want to set this, though, in the larger context of the Second Amendment and its enforcement by the Supreme Court. And that is a very topical issue right now because just a couple of weeks ago, for the first time in over 8 years, the U.S. Supreme Court granted argument and plenary review of a Second Amendment case. Those of you who know this issue a little bit or who have studied it in constitutional law or in one of my classes know that in 2008, the U.S. Supreme Court first clearly held that the Second Amendment protects a personal right to keep and bear arms, or as the court characterized it in the McDonald case, an individual right to keep and bear arms for the purpose of self-defense. In 2010, 2 years later, a majority of the court held that that right was also a fundamental right that was fully incorporated, as the jargon goes, against federal and state governments, against state and local governments via the 14th Amendment. So just like not only the federal government can't violate your right to freedom of speech or religious exercise, the state government is bound identically by those rights. That's true of the right to keep and bear arms as well. Since then, the court has not granted any cases. And so that's why, you know, when the court announced a couple of weeks ago that it was going to decide whether a somewhat bizarre New York City gun restriction violates Americans' Second Amendment rights, you saw some coverage in the media saying it would be the biggest Second Amendment case in nearly a decade. And at one level, that seems odd if you know something about the case, because the law is such an outlier among U.S. jurisdictions. The New York City law at issue makes it generally illegal for a New Yorker who has already gone through the Byzantine and expensive registration requirements just to legally own a firearm in New York City. It's illegal to transport your locked up, unloaded gun to a shooting range in upstate New York. If you have a second home outside of the city limits, you can't transport your legally owned gun there. Or to Connecticut, or to anywhere else outside of the city. The only places you can take it are the 7 authorized gun ranges within New York City's 5 boroughs that are allowed for practice for New York City's 8.5 million people. And yet the biggest case in years label is correct because of the Supreme Court's, you know, I would say record of nonfeasance in the past 8.5 years in the face of what has been often frankly abusive treatment of Second Amendment rights and of the court's precedent in D.C. v. Heller by the lower courts, to the point where, you know, one UCLA law professor recently approvingly described Heller as basically having been underruled by the lower courts and wrote a law review article about it. Others have said how great it is that the analytical approach in the case is not that the lower courts have taken is not the one in the Heller majority opinion, but in Justice Breyer's dissenting opinion. To give you some of the flavor, courts have said things like, even if the Second Amendment right includes, as a component of a fundamental right, carrying firearms outside the home for self-defense, nevertheless, it's a permissible regulation to ban most citizens from ever being able to get a concealed carry permit, because it would serve, among other things, the government's interest in reducing the number of guns on the street. There's a case that held that, a case involving actually a Federalist Society regular, Judge Frank Easterbrook, upheld a ban on common rifles on the ground that even if it did not actually reduce criminal violence, it would promote a feeling of safety among the citizenry, and treating that as a basis for a restriction on a fundamental right. There's a case where there's a cert petition pending before the court right now, Mance versus Whitaker, where a majority of the en banc Fifth Circuit held that the federal ban on interstate handgun sales, and so the way federal law works is if you're an Oklahoman and you want to go to Texas to a licensed gun store and purchase a gun, you can do so as long as it's lawful under the laws of both states. Just as with any other purchase from a licensed gun seller, it has to be called in and run through a central background check with the federal government, and if the approval goes through, you can buy a rifle or shotgun, but not a handgun, because federal law provides that you can't buy handguns interstate, even from a licensed dealer, and even if it's perfectly legal under the laws of both states. Now, you might think that some relatively modest level of constitutional scrutiny should be applied to a law like that. I would disagree, but if you do think so, then I think it's defensible to say that might satisfy a weak level of intermediate scrutiny, even though Con Law 101, right? There's a narrow tailoring gap there. If this is so important, why can you buy an AR-15 across state lines but not a handgun? But the Fifth Circuit held that that law satisfies strict scrutiny. That is the level of constitutional scrutiny that applies to content-based restrictions on your right of free speech, that applies to racial discrimination. And so there is a serious problem with that approach to constitutional scrutiny, and either this is a made-up, improvised thing that we're calling strict scrutiny that just applies to the Second Amendment, in which case there's a problem with lawlessness, or it's going to metastasize into other rights, and then that's a problem that anybody should care about. So the situation is one that calls out for Supreme Court review. I'm glad the court has taken the case. I think that it's hard to see why the court would have chosen to review such an unusual piece of legislative harassment unless there were 5 votes to overrule it. But I think it'll be interesting to see whether the court is willing to apply principles that will apply beyond the particular factual context of this case. And that's something that I hope to follow up on. Have I used my time?
You still have 2 minutes.
I have 2 minutes. Okay, good. We'll stay a little bit. What I think should be, at a minimum, should factor into the court's resolution is, after 10 years, it's time for the Supreme Court to actually give an example of applying a level of constitutional scrutiny to a Second Amendment case. The court's opinion in Heller said that we don't need to pick a level of constitutional scrutiny because this would fail, the handgun ban in the District of Columbia failed any level of scrutiny that you would apply to a fundamental right. And furthermore, the court suggested that we didn't need to apply scrutiny anyway because a ban on a whole category of commonly owned firearms is categorically unconstitutional. And there was some language in the opinion suggesting that while we know there are many things that are unsettled at this point about the Second Amendment right, we'll fill them out in our normal fashion in later cases. Well, it's been about 9 years, guys. So it's particularly, like I said, with the just frankly abusive approach to intermediate and strict scrutiny that a lot of the lower courts have entrenched themselves in using in Second Amendment cases. The court should walk through the intermediate scrutiny requirement, if that's what they think applies, and explain why this is inadequately tailored or why there's not a sufficient government interest in play, and provide some guidance to lower courts in other cases. I would also, at a minimum, hope for the court to use this to fill out some of the corollary or incident rights to the right to keep and bear arms. Even if the court doesn't want to turn this into a right to carry outside the home case in the broadest sense, and there are petitions about to reach the court just in the next few weeks that will squarely raise that issue, and I hope the court takes one. even if you don't do that, this is a great case to expand on the fact that, look, the right to own arms for self-defense logically includes a right to practice with them, to travel with them in ways that are completely, ordinary and commonplace in 99% of the country. Yes, you can go to a range elsewhere in the state to practice with your lawfully owned handgun, and to start to give some substance to those aspects of the right as well. If the court just does that, I think one can call it a success, though I hope that the court will also begin to set the stage for another issue, which is a general right of law-abiding citizens to carry handguns for self-defense outside the home.
Well, it's clear to me what my function in this discussion is. I'm here to defend paranoia. With the Supreme Court decision to grant review in the New York City Rifle Club case, I do think we're going to get much more information about what the court believes is the appropriate level of scrutiny. But I'm here to make a general plea for a basic idea that I think has roots in the original understandings of both the Second Amendment and the 14th Amendment and in American tradition. And that tradition is local government discretion regulating when, where, and how guns may be carried, used, displayed, and particularly brought into downtown, whether it be downtown Dodge City, downtown Los Angeles, or downtown Chicago. I have no quarrel with the idea that a right to own a gun in your own home to defend against threats in the home is a core fundamental idea. I think I would personally prefer that it was associated with principles of individual autonomy rather than the Second Amendment, largely because I think the Second Amendment was inspired by Bunker Hill, Lexington, and Concord. It was a public and political right designed to create a balance within the American system. Many people regard some of those thoughts as antiquated. I won't argue that now. I think that was just the historical development of it. It was about all willing citizens having rights to keep guns in their possession so they could bear arms, and that was a technical term. What gives government the right to do anything about it? Well, the basic police powers. The right to take all reasonable action for health, welfare, and morals. The question now is whether we're going to conjure up phrases developed for other rights and other concepts like strict scrutiny, fundamental right, suspect classification, content discrimination, and create a fundamental right for individuals or groups to carry weapons like cowboys in old Western movies, or worse, like gangsters in more recent movies. I don't think that right was ever a fundamental right. I don't think it bears a resemblance to publishing or assembling or campaigning or voting or writing. And I think it is a dramatically gross distortion of the history of civil liberty to put gun possession, gun transport, gun carrying, concealed weapons all in that group using the same tools. I think that's just going to carry us into dangerous territory. Hence my paranoia. It is a strange time where we would think that transportation, assembly, gathering of individuals with guns is a formula for peace, order, stability, which I thought was what the Constitution promised and what conservatives value. Instead of relying on what I think is an indistinct group of precedents, someone once said, looking at these line of precedents, so many courts, so many people, so many opinions. The truth is there's not much in the way of a detailed consensus, either on things like concealed carry or open carry. But I do think the confusion leads to the conclusion that they thought the Second Amendment was a federalism-specific rule that left most of these issues to local communities, which could then decide whether they're peculiarities of an urban situation or a rural situation or personal need, to balance out the rules. One quotation to bring us back to some of the original thinking in the area. Joseph Story, in his discussion of the Second Amendment, he said it's a public right. It's the palladium of our liberties. It's about allowing communities to defend themselves against tyranny and outside threats. Then he added, it cannot be disguised that among the American people there is a growing indifference to any system of militia discipline and a strong disposition from a sense of its burdens to be rid of all regulations. How is it practical to keep the people duly armed without some organization? It is difficult to see. There is certainly no small danger that indifference may lead to disgust, and disgust to contempt, and gradually undermine all protection intended by this clause of our National Bill of Rights. We dare not lose sight of the textual reference to a well-regulated militia. And using the definition we often confront, a well-regulated armed population, subject to background checks, subject to rules of training, subject to rules of discipline. States ought to have the opportunity to do that. Another case from Tennessee in 1840, just one of many cases doing different things with respect to these issues. It's called the Iamet case. One of the quotations from this case that has often been used in recent discussion. A man in pursuit of deer, elk, and buffaloes might carry his rifle every day for 40 years, and he might make it on his own. And yet it would never be said of him that he'd borne arms. Much less could it be said that a private citizen bears arms because he has a dirk or a pistol concealed under his clothes, or a spear and a cane. This was a case about whether you could have a Bowie knife concealed in 1840. This was at a time when Tennessee thought much better of Bowie knives. But they said no. And they said no for a reason that I think is at the heart of local discretion on these questions and must be preserved even in this New York case. Suppose it were the whim of a set of ruffians to enter the theater in the midst of a performance with drawn swords, guns, and fixed bayonets, or to enter the church in the same manner during service to the terror of an audience, and this were to become habitual. Can it be said it would be beyond the power of the legislature to pass laws to remedy such evils? Surely not. This was something the founding fathers and subsequent generations feared, and I think we ought to keep it in mind before we let ourselves get carried away by strict scrutiny, before we allow strict scrutiny to grease a slippery slope to where we have something closer to anarchy rather than ordered liberty. I sometimes ask my students about this time, what's your favorite Western? And the answers have changed over the years, but at least a segment would say My Darling Clementine if they're old, Gunfight at OK Corral if they're less old, Tombstone more recently. Tombstone seems to be the one that triggers it. I would ask you to remember that when the Earps and Doc Holliday walked down to the OK Corral, they were enforcing a local government gun control law. And a lot of Western communities wanted to climb out of the violence of the Wild West, which has often been exaggerated, and prevent guns from gathering and assembling, and gunmen from gathering and assembling, liquoring themselves up and doing all sorts of nasty things. We have to have an authority to deal with those situations. And creating strict scrutiny to sweep away these regulations can only lead us to a disaster. So speaks the paranoid.
Thank you. And now I'm going to allow each professor about 3 minutes to do any rebuttals. If you would like, starting with Professor Blackman.
Thank you. The debate in Heller boiled down to this. Was the Second Amendment a right for the individual, or was the Second Amendment a right that concerned the militia? And Justice Stevens marshaled a volume of historical evidence about the right, suggesting, as Professor did, that it was a right concerning the rights of the militia. And Justice Scalia marshaled a volume of evidence suggesting that this is a right that's borne by individuals. I'm not going to rehash that. It was a 100-page debate. What I would note is that both the majority and dissent felt compelled to be originalist, in different strands perhaps. But this was not decided in some sort of living constitution approach. It was decided based on what the founders thought. Now, if we did use living constitutionalism, we have carry in how many states, Michael?
43.
43. So there was a right in 43 states. That's pretty good. If we actually use modern approach, it's a vast minority of states that have these oppressive gun laws. So I think in some regards, gun owners would actually fare a lot better with modern living constitutional approaches. But we'll leave that aside for now. What I would like to note, though, is that a lot of the concerns about firearm laws are again premised, I think, on somewhat irrational fears of how guns operate. We don't argue that these guns can't have metal in them. We don't argue that they can't be serialized. Argument's a lot more narrow. That the First Amendment, free speech, says you can't stop me from putting a file on the internet. That's a means of sharing information. And even if you don't care about guns, this bleeds to other areas. So imagine the government puts a law saying that you can't put on the internet a file used to 3D print a pair of Nike sneakers. That's actually where this gets big, right? 3D printing is not about guns. No one cares about guns. It's about counterfeited goods, right? So if I can 3D print a pair of LeBron James, or sorry, Russell Westbrook sneakers, right? In fact, remember where I am, right? Don't say Durant, right? If I can 3D print a pair of Westbrook sneakers, right, and not pay $400 for them, that's saving a lot of money. So the sorts of restrictions that we're talking about here, I think, will bleed far beyond guns. But I'll stop in terms of my friends.
The general point I want to make is it is okay for you in responding to arguments about the scope of the right to arms and what the court should do with it to acknowledge reality. And part of that reality is this. There were a minority of sources that talk about the Second Amendment in American history, the way Professor Tepker talked about, and they said things like this, that the individual citizen, the very case he was quoting, had an unqualified right to own the ordinary military equipment in order to keep in awe those in power. And in a later case, that same court clarified that includes the rifle of all descriptions. So let's be clear. If people like Professor Tepker are making the argument that we should abandon the self-defense, human rights-based conception of the right to arms that Heller did and replace it with the idea that those courts actually had in mind, which means I'll be generous and not say you all have an individual right to own an M4 machine gun, and I'll just say you would clearly have an individual right to an AR-15 with a 30-round magazine, which is what you need to be a member of the well-regulated militia in 2019, then we can talk about that, and we can go there. Or we can actually go along with American tradition in this area. And what that tradition includes is the first academic commentator on the Second Amendment, St. George Tucker, writing in 1803 that as an illustration of what the right to bear arms meant in America, noting that an American gentleman won't walk outside his house without his gun in hand any more than a European gentleman would leave the house without his sword. That's the right to carry. There are state Supreme Court cases recognizing a right to carry handguns and other common weapons outside the home for self-defense from the 1820s, Bliss versus Commonwealth, the 1840s, Nunn versus State, the 1850s, State versus Chandler, the 1870s, Andrews v. State, the 1900s, an Idaho and Vermont case that threw out municipal bans on gun carrying, just like Professor Tepker was talking about, the 1920s, the 1980s, the 2010s, Delaware and Illinois have handed down decisions like that just within the last decade. 43 states. Don't let yourself be, it's a lesson that is useful to learn in this context because it is so clear and so stark. And then I urge you to apply it to other areas where rights that happen to have a populist character and not to be very popular with the cultural establishment Now it's time for moderation. Now it's time to learn nuanced lessons from history. The tradition is overwhelming. The most common type of law throughout American history to be struck down as a violation of the right to arms is bans on carrying outside the home. And so if you want to go back to everybody has a right, a virtually absolute right to own the standard infantry weapon, then we can start taking issue with the right to carry and the self-defense aspects of the Heller decision. But that's not what's being sought when this is argued. The court can vindicate we've even done, you remember the thing in con law about Brandeis and the laboratories of federalism, that you let things percolate through the states before the national government or the Supreme Court acts and recognizes a full-fledged constitutional right? There have been shall issue concealed carry laws in a majority of states for over a generation now. It's 43 states now. We got these tiny little islands of holdouts on the coasts. That's a lot more than was done for abortion rights. That's a lot more than was done for same-sex marriage. When the legal sources are all lined up, and we've tried it, Josh's own state of Texas compiles meticulous details about the facts and figures of concealed carry users being involved in crimes, and for years they've been far lower than the population as a whole. When all of the traditional indicators of constitutional meaning line up in support of a claim, it is not only appropriate for the Supreme Court to do it under current conditions, with Americans noticing and not being ignorant of what the federal courts have done in so many areas of our law for the past 50 years and more, in areas where they didn't have an enumerated right, a strong state court tradition, 43 states on board. The way to avoid paranoia is to vindicate this rights claim.
Well, I guess I'm not only paranoid, but I have to admit I'm from one of those communities on the coast, not in the 43 states. I was born and raised in California. But since then I've lived basically in Oklahoma and North Carolina. And, you know, just a matter of personal judgment when it comes to Oklahoma, I don't have any guns. I'm living in town. I do own guns in my farm in North Carolina for a wide variety of reasons. It seems to me that the 43 states, even though it's disproportionate, emphasizes local discretion, local control, local assessment of these issues. It's just not the same issue in New York City as it is in Sparta, North Carolina, which is in a county which has one stoplight. It's just not the same issue. And I think strict scrutiny, fundamental rights obscures that. It creates an argument for a need for a national, uniform set of practices, and I don't think that case has been demonstrated. I have no difficulty, one, with the principle that it's an individual right to have a gun in the home. I do not disagree with Justice Scalia's analysis on that point. I do not have any doubt that states ought to have the power to grant authority for open carry and concealed carry. But I don't quite know why we want to have a uniform, national, federal constitutional standard to displace local community or state discretion on these questions.
Thank you, professors. And now we're going to move into the question and answer portion. So yes, if anybody has questions, I'll bring the mic to you, and we have about 10 minutes for that.
Thank you all for coming and for your very eloquent and passionate presentations. What I want to ask, though, is that if you would take off you've made very compelling cases, to take off that hat and put on your hat of sheer prediction of what you think will happen perhaps as a result of the New York case at the Supreme Court, and if you have any broader predictions of where that might lead with other cases being granted or denied.
Mike?
Yeah, I'll tackle that one. And any predictions I make will have a short half-life because the court has granted the New York case. There is, I alluded to this case, the Mance case, M-A-N-C-E, out of the Fifth Circuit, that involves a challenge to the interstate ban on buying handguns from a licensed dealer when it's legal under the law of both states. That petition is being briefed before the court right now, and they'll decide whether to grant it pretty soon. If they grant Mance, I can't think of any way to interpret it other than the court wants to acknowledge to really acknowledge that the right extends to limitations on how much you can prohibit commercial transactions and sales, and it's a right to acquire guns and stuff like that. Then there's a carry petition in a case called Rogers versus Gruel. That's the Attorney General of New Jersey, Grewal.
It's pronounced Greywall.
Greywall, thank you.
There you go.
That's right.
I've sued him
Is he
enough.
a relation of the professor? Okay. Professor with that last name too, so I'm glad I know that. And it's a case out of the Third Circuit that challenges New Jersey's very draconian laws on handgun carry permits. And there is a hard circuit split on this. The D.C. Circuit in 2017 held that D.C.'s very restrictive carry permit laws violate the Second Amendment, and that decision is final, and D.C. is shall issue, which I have to say, it's not about Sparta, North Carolina, it's Pittsburgh, Phoenix, Arizona, Kansas City, Dallas, Seattle, Washington. These are urban areas, and they've had shall issue carry rights for years, and in some cases decades. There's nothing special about New York City, other than there are people who live there who don't like gun rights. The Rogers case is a very tempting carry rights petition, and it's going to be before the court. They'll decide whether to hear it this term. They would hear it in the next term that starts in October 19th, so that would be a year. So pretty soon we're going to find out with the response to these two other petitions whether the court really wants to weigh into the Second Amendment again, which I hope they'll grant on both. I predict that I think we're going to get some guidance about how to do constitutional means-end scrutiny in the Second Amendment cases. I think the court's going to reverse in the New York case and hold that this is invalid. I feel reasonable confidence that the court is willing, as I might put it, to affirm a genuinely substantive, a meaningful right to keep arms, which I think includes you can't have arbitrary restrictions on the ability to acquire arms, you have the ability to transport them to practice, etc. And so Mance, I would kind of lean toward maybe they'll take it. Rogers, man, that's tough. I'm going to say they'll take it, but I hope I've conveyed that one I'm genuinely unsure about.
My prediction will be a little shorter, and also with the disclaimer that I keep predicting the Dodgers will win the World Series, so I'm coming a little closer within one game a couple of years ago. I think they will reverse in the New York City Rifle Club case. I think they will give us guidance. I don't think they will give any real sustenance to a truly deferential rational basis review. I suspect they will not use strict scrutiny except for the core private home right, which means we will be left with the muddle in the middle, the intermediate test. I would suggest, as a point of consensus, in search of a consensus, that government ought to bear the burden of proof, that it must show its regulatory means are effective with some data, promoting substantial ends. And that ends up being balancing. When it comes to overbreadth, there is so much overbreadth that's just inherent in the nature of using English language to write laws. And there's much diversity in the court formulations, reasonable fit, narrow tailoring. I think I would prefer a reasonable fit requirement rather than a narrow tailoring requirement.
Do you think just Judge Eastbrook's standard that it makes people feel safer would be sufficient data?
Yeah, is that an important government interest that could pass intermediate scrutiny?
If I was litigating, I'd want to argue yes. If I was betting, I'd probably bet no.
Fair point.
And I will also say, actually, here's something I sometimes think about with intermediate scrutiny and what counts as an interest. So on the one hand, I think it's disturbing to think that you could ban a common class of arms because even if it didn't actually reduce criminal violence, it would make people feel safer. On the other hand, I would be it would give me pause to think that you couldn't require concealed carry rather than open carry, not maybe on somebody's own property, but at least in public spaces. And that is traditional. There's a traditional view that the government can ban concealed carry as long as it allows open carry, in a visible holster, or presumably vice versa. But what's the government interest in that case? It's got to be something like people's response to seeing a gun in contemporary society. And I suppose I would reconcile those by saying restricting a mode of carry has a historical pedigree as a permissible mode of regulation, and you're not prohibiting somebody from bearing arms, and you're not even substantially burdening their ability to bear arms. They're just saying you got to keep it hidden. And so, but I do think that's a regulation that I wouldn't apply strict scrutiny to, and that I would also be inclined to uphold as constitutional in most cases.
Okay, another question.
Who here has class at 2 o'clock?
Not my students.
Okay.
I gave them an extra 15 minutes. So
If you need
I'm
to get up,
watching you.
go, and we'll stick around whoever's left.
A seminar in Lorman at 2:30, so
How about this? If you need to go, go, and we'll take questions.
Okay, very
Thank you all so much. Thank you, sir.
Are you going to go?
No, I don't. I'll stick around. Thank you so much, sir.
Thank you. Take it easy.
Thank you. Safe trip back to Norman.